Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that's about kink. And it's also about some issues of trial fairness or fairness to the accused in the trial process, as well as issues of liberty, but mostly it's about BDSM. So let's dive in. This is the case of the King and Pearson. Now, you'll note here, I've got the person's first name blacked out. Now, this is actually released in a public document, so that information is out there. You can search it. I'm just not putting it on blast in this video because the accused is acquitted in this trial. He's found not guilty. Now, when I said I was going to talk about issues of sort of fairness in the trial process, you'll note here we've got a restriction on publication. And it says, subject to any further order by a court of competent jurisdiction, an order has been made in this proceeding directing that the identity of the complainant, so the alleged victim, but keep in mind, acquitted here, and any information that could disclose such identity shall not be published in any document or broadcast in any way pursuant to section 486.4 of the Criminal Code of Canada. Now, I don't know this person's name, but if I did know their name, it would be illegal for me to tell you. I could be jailed. I could, face sanctions from the Law Society. I could all sorts of things. But his name still makes the front page, even though he was acquitted. And so the question is that really fair? Especially given that these are sexual assault charges. Okay, so that's kind of our first issue and our first thing to think about. But what happens in this case? I'm going to be very circumspect as to the facts because otherwise YouTube will be angry with me. So I'm going to describe them in very broad terms. And basically, some of these activities involved leaving bruises or marks. Some of these involved, there was a stapler involved. I will let you use your imagination. And there was also issues of large objects being put into small places. That's about as specific as I'm going to get here. Now, she said that she didn't consent to any of this, that this was all something that, that this was non-consensual activity. However, the court found some serious problems with her credibility. The background on this is that the woman in question, SL, those are initials, she advertised online that she was a submissive and she was looking for a dominant partner. And this guy responded, they sort of arranged things, and they agreed to meet up and engage in activities. These activities, amongst other things, at some point, she was bleeding a little bit. And they sort of stopped the bleeding, and they proceeded. They had a contract. They had all sorts of things. So, the main issue in terms of whether Mr. Pearson was, to be convicted was, first, whether or not there was consent. Now, as I mentioned, her credibility was shaken badly. It was not the court found that there was some serious problems there. They found his credibility was good. They said he was credible and his testimony was reliable. But the further problem is a rule in Canada. I've previously gone over this with a case called Jobadon, and that rule says that you cannot consent to activities that are intended to and which cause bodily harm. Now, bodily harm is a very low standard. Bodily harm can include bruising. Bodily harm can include like a split lip. Bodily harm can include all sorts of things that we otherwise wouldn't normally think of as sort of serious harm. Now, the court here said, well, we can't say that there was, that there was any intent to cause bodily harm based on believing his evidence and not really believing her evidence. But they ran into some larger issues in terms of what the court says is BDSM and social value. So this is a question sort of for the world. And this one is kind of interesting. So postscript, BDSM and social value. Now this is purely obiter, which means that it doesn't form part of the sort of binding section of the decision. This is just the judge commenting. It's kind of an aside there. This is the judge providing a signal to the courts and to Parliament that maybe they should think about some issues. So let's have a look at what they talk about here. And again, I know I'm being a little circumspect, but we'll read through this. They say, as discussed above, both the Crown and defense advanced arguments and called experts regarding whether the law should be changed such that certain BDSM practices ought not to fall under the category of activities to which a person cannot consent to bodily harm. So what this means, if you're watching this going, wait a minute, is it legal to be kinky in Canada? Well, if your activities involve causing bruising or, marks or bleeding or anything like that, then the answer is probably no. That even if you think you're consenting to them, the courts think you aren't. The courts are like, no, we need to get involved here and we need to say that's not cool. Now, this is going to be a controversial thing. I suspect I'm going to get some people yelling at me in the comments, probably from both sides on this one. But I'm just largely going to be talking about what the court says here. So, the court continues to say, the issue is whether the law on consent to bodily harm as it currently stands reflects today's social norms, practices, and values, or should be changed to do so. Although I need not decide the matter, and the court doesn't decide the matter, I would note that the defense has put forward a compelling case that the matter should, at a minimum, be re-examined. The court says, as the law stands now in Ontario, a person cannot consent to the infliction of bodily harm in the context of a sexual relationship. The standard of bodily harm is not a high one. Bodily harm is defined as any hurt or injury to a person that interferes with the health or comfort of the person, and that is more than merely transient or trifling in nature. I have emphasized the disjunctive nature of the definition hurt or injury, health or comfort, transient or trifling, to demonstrate the wide spectrum of situations that are potentially captured. Okay, let's take a break from reading to just mention here, any hurt that is beyond trifling and interferes with your comfort can count here. The courts have found that being pepper sprayed, for example, is bodily harm because it causes, pain, discomfort, and lasts for maybe a couple of hours. Now, if you think about, bruising, as might happen with, say, spanking or caning or any of these kinds of things that people get up to, and they got up to in this case, then this could very well qualify. And the question is, should the court be the one to make that decision? All right, let's have a look at what the court has more to say here. And specifically, they actually are looking at the Crown Prosecutor's expert, which is interesting because the Crown Prosecutor's expert actually ends up supporting the defense position here. So it says, it will not be uncommon in BDSM to intentionally leave marks that would meet this definition. One such scenario was put to the Crown expert, Dr. Dominique Bourget. The following exchange occurred in cross-examination. Okay, so I'll give you a BDSM hypothetical where two people who have no mental health issues, they're in a long, serious relationship, have been married for 30 years, they engage in consensual spanking on the buttocks that they both intend would leave some redness, which fades completely after about 4 or 5 days, okay? Is it your opinion, your psycho... I think that was supposed to be psychological, but it just ended up being psycho opinion. But, your expert opinion that under no circumstances should those people be allowed to engage in that behavior? Answer, no. Question, okay, in your opinion, that would be something that people should be able to consent to based on all of your research. Answer, yes, that is something that I don't see unless somebody has a concern that one of the partners does not have the capacity to consent. I do not see that the law would want to intervene in a situation like this? Question, sorry, or more correctly, you don't see based on your clinical and research experience why that should be prohibited by the law. Is that fair? Answer, correct. Question, okay, and just to extend that a little bit further, if that same married couple engaged in spanking which left redness for 7 or 8 days, you'd have the same opinion, correct? Answer, I have the same opinion, especially if there's neither of them complained about it to police. Question, if both of them were consenting, in other words, correct? Answer, exactly. If they were both consenting and not making a complaint because it went too far or there were other issues but I think that these are fair examples of, a stable couple, consenting activities, and between the two of them in their own bedroom. Transcripts include a lot of little hesitations and so forth that end up feeling weird when you're rereading them, but okay. So, the court notes, the Crown expert did not view the conduct in the hypothetical scenario as worthy of criminal sanction, and yet such conduct would almost certainly meet the definition of bodily harm, i.e. those examples that were given that the Crown prosecution expert said should be legal are things that the court currently, under the law, would find to be illegal. Now, I know there's going to be some viewers here who engage in those activities. Just playing the odds. It is a certainty. I know that I have some viewers who do this professionally to people who not only are consenting, but pay money to do it. So, yeah. So the court notes, the result would be a conviction for sexual assault with all of the serious repercussions that stem from that, i.e. serious jail time, going on a registry, all of those things. So in addition, the defense led evidence about the social benefits of BDSM through Dr. Charles Moser, who is presently employed in the United States practicing internal medicine and sexual medicine. He's authored and co-authored a wide array of publications on BDSM and other topics related to sexual conduct, and has been previously qualified by courts in the United States and Canada as an expert in BDSM. That's a hell of a thing to have on your resume. Expert in BDSM. Okay, cool. According to Dr. Moser, approximately 5% of the population engages in BDSM to the point of recognizing it and naming it as such. Now, that means that there's probably other people who don't name it and aren't sort of, but still engage in some of those activities. So that would equate to approximately 1.9 million Canadians, that's a lot of people, who would report engaging in BDSM in some form if queried. Dr. Moser further testified that over 50% of the general population at least engages in fantasies about BDSM behavior. As for the value of BDSM, and guys, if you're in the comments, you don't need to tell me. We're good. So as for the value of BDSM, Dr. Moser noted the following. A, mental health benefits, personal growth, self-actualization, connection with partners and community, and therapeutic benefits, including navigating trauma. A fair bit of that is people like it, I guess is a way to phrase it, but also just being able to choose the things you do tends to make people happier, if that also makes sense. So B, an understanding of the activities as a form of expression that can encompass physical, verbal, sexual, artistic, visual, poetic, social, and political expression. I'm not sure where political expression comes in here, but okay, I'm going to assume that was explained at trial. And maybe I should reach out to this guy and be like, hey, do you want to talk about this? That might be fun. And engagement representing an equally important part of participants' identity as members of the LGBTQ plus community and general public view their sexual orientation and gender identity. Historically, some of the laws targeting this kind of activity have been deployed against those communities. That is particularly true with regards to obscenity law, which says that basically any combination of sexuality plus violence is obscene, which would include a lot of BDSM content. I think that maybe there's probably, if the court thinks that there's room to revisit this, then they might think that there's room to revisit that as well. But that's for another case later. So the court notes, these types of benefits were not considered by the Court of Appeal for Ontario in R.V. Welch, or the King and Welch. Would have been the Queen, I guess, given that it's 1995. All right. In fact, the court appeared to accept the general proposition that hurting people is wrong. So Welch is the previous case and basically said all of this stuff is illegal. So, and that if sadism is allowable, if consented to, then it is consent rather than moral conviction, which polices the barrier between a society of would-be sadists and the kind of society most of us would like to inhabit. Now, personally, I am fairly liberty-focused. I would like to inhabit a society where my personal sensibilities are not the determination of whether or not something is allowed. When I said that this implicates liberty issues, what I mean is that one of the most fundamental metrics of liberty out there, in my opinion, is the difference between the activities that people say are, they don't agree with, and when things start to become illegal. The bigger that gap, the more liberty one experiences. You can put this in the form of speech. How much speech does this society allow that other people deplore, that other people think that that speech is awful and would want to shut that person up if they could? The same applies in all sorts of other scenarios. Now, I am not this person. This case doesn't affect me directly. I guess I'm maybe revealing a little too much about myself, but okay. I am boring. But I do like engaging in other hobbies that many people find deplorable. I like going target shooting. And yeah, I want people to leave me alone when I go target shooting. I want people to let me do the things that make me happy. And similarly, I think it's important to let other people do the things that make them happy, so long as they're not hurting anybody without their consent. So now the court goes on to look at a further interesting issue. And this is, so Jobadon, the case that sort of initially said that bodily harm was the standard, put exceptions. And one of the exceptions that they sort of recognized in that case was sport. So that people can box, so that people can play hockey. Because, there's a lot of punches thrown in hockey. But they note here, if this is so, one wonders why the much more extreme violence found in mixed martial arts, MMA, is not sanctioned. As pointed out by the defense, in MMA, extremely serious injuries are intentionally caused to win a fight. Noses break. Bones break. It is not criminal assault if both parties consent to the activity. The vast majority of Canadians, surely, do not engage in this practice. I don't think that... I would agree that MMA is engaged in by very few Canadians overall. Presumably, a minority of Canadians have no interest in watching that particular sport. Many will not understand how a fan watching such violence could be entertained. But some people derive some value from it. And so the court seems to be saying, shouldn't we recognize that value? Shouldn't we allow that? Why not in this other context? So, in light of the evidence of both the Crown and defense expert in this case, a similar argument could be made for BDSM. A majority of Canadians do not engage in it. A sizable minority may not even fantasize about it. Many will not understand why anyone would want to engage in it. But again, some people derive some value from it. Of course, there are tricky issues about where the line should be drawn, just as there is in MMA. Like, MMA probably wouldn't be allowable if you, gave everybody knives, for instance. So those issues are not insurmountable, however. When Welch was decided, the English and Canadian Law Reform Commissions proposed to have Parliament enact legislation that recognized consent as a defense to an assault, except where serious injuries result, with long-term consequences. And the American Model Penal Code proposed consent as a defense where the harm is not serious, and the conduct and harm are reasonably foreseeable hazards of joint participation in a lawful activity. Although the proposals to Parliament were not accepted in England and Canada, some American states have adopted the Model Penal Code's approach in their state criminal codes. By statute, these states require a higher level of bodily harm to result for consent to be vitiated or canceled, right? If consent is vitiated, it means that even though you think you're consenting, your consent is not valid. We just say, as a matter of law, you cannot consent to this. So, for example, people who are under the age of consent. And this can, in some cases, be interesting because, for instance, in Canada, the age of consent generally is 16, and then the age of consent for somebody who's in a position of sort of authority is 18. So you can have people who can consent to sexual activity in certain contexts, but not in others. And so, but that is the law, right? The consent is just not valid at all. Similarly, Jobadon was a fist fight, and the court said, I don't care that you guys think you were agreeing to that. Your agreement is meaningless. It is not legally valid. So that is the potential problem that comes up to people in sort of BDSM activities, is that both parties might think that they are consenting. And the court's like, you didn't ask me, though. I don't consent. So these states uphold the defense of consent where the bodily harm consented to is not serious physical injury, does not jeopardize life or seriously impair health, or does not endanger life or cause serious bodily injury. The point is not that any one of these definitions should be adopted. Having acquitted Mr. Pearson on all counts, the issue is not squarely before me. The point is simply that perhaps it is time for Parliament or the appellate courts to consider the issue afresh. So basically the judge says, this is a real issue. Somebody should look at this. But I'm acquitting on the credibility issues, so ultimately this is going to have to go to someone else. Okay. So I expect my comment section is going to be about evenly split between three different main positions. 1, people who are like, wait a minute, this was illegal? This is illegal in Canada? Why is this illegal in Canada? It shouldn't be illegal. 2, people who go, yeah, we think that behavior is weird and we're okay with it being illegal. And 3, people who are going, Runkle, how did you manage to make an entire video on kink so boring? And that one I can answer. It's a special skill. They teach it to lawyers. It's what we're good at. With regards to the other 2, I mean, a lot of this comes down to a matter of opinion. My personal feeling on this one is that the court should throw people in jail reluctantly. And this is, I don't think that these are people who need to be in jail. That's just kind of my philosophy. You may or may not agree with these activities or, whatever, but do we really want to spend all this money to prosecute these people? No. And I don't think agreement should be the same thing as legality. There's all sorts of things that might be of interest to only a small percentage of the population. And, so long as it's consenting adults, so long as nobody is getting, seriously injured or killed, let people do what makes them happy. Anyway, I hope you found this one to be interesting or educational. I'm also interested in this one because it's kind of one of these places where there's a tension point in the law, or a fracture point where the law could change in ways that might be interesting and dramatic. Now, that's interesting if, like me, you totally like geeking out about law. It might also be interesting if some lawyer wants to make a name for themselves and to run the case that ultimately decides this issue. That's probably not going to be me, but somebody out there is thinking it. Anyway, I thought I'd share this with you. I found it to be fascinating for all those reasons, but you may or may not. Let me know in the comments below what you think. So I also want to thank my Patreon supporters. There's a link to that below if you want to join them. At the $50 level, Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Coalition for Firearms Rights, the Canadian Shooting Sports Association, PJs Forever, Angela Skelton, Cielo, Purple Dragonair, Dorky Dane, and, Dorky Dane is at the $20 level, but we'll skip here. Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Marvin CZ, and Dorky Dane, all at the $20 level. Got myself a little turned around there. And thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this armed you with knowledge. See you next time.